Oh, thank you very much, Khaled, and thank you very much, Smit Shah, for joining us. Huzefa, Prashant, and Harshil, and all of you have been a wonderful panel with so much insight and knowledge into the space. So, as you all know, participants, first of all, thank you for joining in so many numbers, and we are very excited to have you all. Uh, some time ago we had a session on drones, opportunities, and issues, and other kind of stuffs as far as drones are concerned. Now we are going to discuss, the drones in a different setting. What is the difference? The earlier drone policy that we discussed related to the manned drones, because no unmanned drones are otherwise permitted, and drones is likely to be the largest employment creator, because no, with two people manning it, and plus other kind of services, and the other spillover effects that will be seen, will create a lot of employment. Now we are looking at unmanned drones, and I think what are the benefits, what it is going to do, what unfolds, what are the issues, and all that will be discussed in today's panel. But drone is a very exciting space, and as you heard us before, that we even specialize on an autonomous car, but then now on the flying cars. So in 5 years' time, flying cars will be a reality, and in 10 years' time, it may be what I would call common mode of transport. Okay, and with more so with the situations like COVID and other kind of stuff, this space is extremely important and useful, and we must really assume global leadership in this particular arena. And so I would like my colleagues to take over from me now and tell you more about this, opportunities, issues, and how can we resolve them together. Most welcome once again, and over to you, Huzefa.
Thank
Thank you. I
you.
think you have worked on the regulations in the past and otherwise as well. So your contribution again, I would like to acknowledge in the policy work framework. Thanks a lot.
Thank
Over to
you.
you.
Thank you. Thank you so much, Nishith bhai, for actually laying this out for everybody. I think most importantly, let alone India, right? Globally, in the past 3, 4 months, there has been a tremendous acceleration for the drone ecosystem. Just tracking back things, approvals have got accelerated, whether it is for commercial deliveries, usage of drones by security agencies, specifically from a health and safety perspective, approvals for drone discharges, specifically when it comes to disinfectants. Everything has propagated and propelled the influence of drones in an urban ecosystem. In fact, just day before yesterday, US and Switzerland have also executed a multinational and multilateral research agreement specifically focusing on drones. Just a few months back, EASA, which is the European Agency for Safety Regulations, has also released its opinion and views on standards of adoption of drone in an urban ecosystem with necessary bells and whistles. So, the overall intent seems to be clear globally that more and more penetration of drones is going to come into our urban lives, and the interplay between civilian use and urban, let alone defense. Now, what does it mean specifically from an Indian perspective? And I know today's session we are going to talk about a new law, a new draft law which has actually been published, new draft rules. But actually, just take a step back, right? I'll just give you a 1 minute download in terms of where and what are the updates from an India front. As most of you all will know, prior to December 2018, usage of drones in India for civilian purposes was not allowed. It was a complete ban. December 2018 is when the first drone regulations came in into India, which actually permitted civilian use of drones, subject to the bells and whistles which were there under that draft. And from December 2018 till today, which is just a short span of 20 months, I think the drone ecosystem with the Ministry of Civil Aviation has made tremendous achievements. Very quick 3, 4 highlights. First, though the initial regulations were just in relation to visual line of sight, there were BVOLS, which is Beyond Visual Line of Sight's expression of interest released in May 2019. Following that, around 10 to 12 companies have actually been granted approvals to conduct their POCs. A little later in 2019, we also released the National Counter Rogue Drone Policy. Following that, in May, there were special exemptions which were granted to government agencies, to deploy drones specifically in COVID times. And lastly, in June, which is this just last month, June 2020, we have an entire new regime from a drone law perspective. The intent is to supersede the previous regulations. So this is a quick overview in terms of what has happened, and now let's just directly dive into it in terms of comparing what the old law was and what the new law is. Probably I can go to Prashant, and Prashant can give us an overview of the existing, drone regulatory framework which is there, and if there are any limitations, and then we can move on discussing the new law. So over to you, Prashant.
Thanks, Huzefa. So now, as you had rightly mentioned, that the regime of civil use of drones in India is fairly nascent, and it was introduced in the late of 2018. And since then, while a lot of developments have been witnessed in this industry, but question is, if you ask that whether all of those objectives that were kept in mind while introducing these laws have been achieved or not, well, the answer to that is it can, I mean, while it is yes, but not to the extent as it was envisaged. But there were certain limitations in those regulations that could be sort of called responsible why we have not achieved the objectives that we intended to achieve. And in a minute's time, I will be dealing into those. But just to give a quick background, as Huzefa mentioned, this was the first set of rules were introduced in August 2018, which became effective from the month of December that year. And since then, there were few things envisaged in that regulation, like in the form of digital sky platform that could have acted as a facilitator for those rules being implemented. However, they remained in abeyance for a longest amount of time, and it was close to the new regulations coming in that we saw some activity happening at that end, and because of which we sense some delays happening in terms of those laws being implemented. Now, in terms of limitations that were there under the existing framework, as Huzefa mentioned, that these regulations were limited to visual line of sight operations and operations during daytime only. Then these regulations allowed remote pilot aircraft systems to be operated, which essentially meant that there has to be a pilot on the ground operating these drones for it to be operated. Then there were other limitations in terms of not being able to carry payload, visual line of sight, operations beyond visual line of sight was not permitted at all. Autonomous operations of drone was also something that was not recognized under this. So these were some of the broad limitations that were there. Besides this, the categorization of drone that were there was done on a weight basis and not on a risk measure basis, which is something that in some form or the other we would see has been introduced under the new regulations. Other than that, in terms of limitations, if we see, there were few authorizations that were granted in the form of who can own the drone and who would operate, but there were few areas that were still ambiguous in terms of whether somebody can trade in those drones, and whether any authorization would be required for that or not. That was also a form of limitation in form of an ambiguity. Then there were questions around use of drones for experiment purposes. If one were to use those, would they require all of those prior approvals before they could operate a drone, even for test purposes and all of that? So these were some of the questions that were in the mind of anyone who wishes to venture into this industry. And to answer most of these questions is what we feel that these new regulations have been introduced. While there are still certain aspects that may be missing in it, but later in our discussions, we'll be touching upon those as well. So over to you, Huzefa.
No, thank you so much, Prashant. From a quick download perspective, I think it is really important from our audience perspective to make them understand that there is already an existing law, but we have a new law which is going to supersede the law. And the good part about the new law, there are some enabling provisions which are there in the new law which were not there in the old law, which is super exciting, and we'll discuss that. And on that note, who better than Smit? Smit Shah is working with the DFI, and he's also heading the partnership arrangements out there, and he has also been ingrained in the drone ecosystem for some years. So, Smith, over to you. It would be great if you could give us some insights on the new proposed law which has been released by the Ministry of Civil Aviation.
Yeah, thanks, Huzefa, for a great introduction. I think I've been more than involved in the ecosystem, just passionate about it. And maybe that's what helps me read through things and maybe put that extra effort that's required currently in the drone industry. When it comes to the new regulation, I think the first insight that we just sort of didn't really understand or didn't really take it in a very sporting format was that the previous regulation was under the Aircraft Act, under the aircraft rules, and it was just a small thing under the traditional manned aviation rules. With the new policy coming out as a rule itself, this is a big opportunity for the drone industry, and it's a really successful initiative that the industry has taken together to sort of have its own set of rules. So I think that is one of the key things that the importance of which many people didn't really notice. Like a lot of things could have been enabled under the Aircraft Act and the aircraft rules, but because the drone industry is not just a small part of the unmanned of the aviation industry, but it's going to probably be equally important or in future more important than the traditional manned aviation industry. Yeah, I believe it's really wonderful that the Ministry of Civil Aviation has acknowledged that and has started this regime of creating a new rule under which all the further civil aviation requirements and the circulars are going to come. So that's one of the key things that I wanted to highlight. And looking at some of the key insights from the rules, I believe what's exciting to see is that the rules in its entirety everywhere talk about digital sky and the online platform. So every rule, every schedule, every form actually talks about submitting the data via an online platform, whereas in the existing rules it was mentioned in some cases, it wasn't mentioned in some cases, and there was a little sort of ambiguity there. So I think a clear mandate of everything happening through a single window platform, which was the idea, but initially as well, but I think it's very wonderfully communicated and very out there in each and every section, every schedule of the law. So I believe that was great. Then if we look at a few things like the new authorization framework, so for everyone who isn't aware, the rules talk about a new authorization framework which authorizes every party, which is the manufacturer, importer, trader, owner, operator, remote pilot, all of these entities as a recognized entity. If you're not a recognized entity, then you are not allowed to sort of own a drone or trade in drone activities. So I believe that is something that clearly identifies individuals and sort of creates a framework in which tracking and liability and uh, ownership of drone and all these other activities, which actually were becoming a problem from a security concern, will be under a single window platform. So just to give an example, there was a worry about, we don't know who are the manufacturers who are trying to make drones, and someone would make a drone at home and probably then just sell it out. All of that was not really regulated. Probably you had to have an NPNT drone, and only after that you come into the government's platform. And so here the authorization is when you start the activity. So if you're becoming a drone manufacturer, you have to sign up on the platform, you have to disclose your identity. And it's great to know that it's just going to be similar to just signing up on Digital Sky platform and just making an account. So it's not really a complicated process that I believe is envisioned. So if you're a trader or if you're an importer or if sort of you are a manufacturer, you just go onto the Digital Sky platform, upload the requisite documents, and create an account. And that's basically what the authorization framework is. So I think that while it is an additional sort of requirement that the law states, but it's great to know that all of these additional requirements are still circled around the single window clearance platform. So it's not that you need a separate authorization license, which no one is aware about, where it is going to come from or whether you need to manually go to the DGCA or not. All of this is still on the Digital Sky platform. So they talk about an authorization which you can apply on the Digital Sky platform, which is like your sign up page of the Digital Sky platform. So I think that really was great. And a few other aspects like recognizing model aircrafts, recognizing autonomous aircrafts. So all of those were things that were a big gap. So with this, the intent is pretty clear that it's not just that there are a few set of drone applications that are commonly sort of being done by the parties. So for example, before 2018, you would generally see drones in sort of 90 to 95% of the use cases for photography and videography related applications. So probably the law was sort of made in such a way that most of the applications are always in visual line of sight. So let's just quickly sort of get a regulation in place and cover that aspect. But this entire law creates the roadmap and creates and recognizes all different types of drone activities. Probably even something like an urban air mobility, which is sort of recognized in some form. With this, the intent of the ministry to sort of recognize the drone applications, the present as well as the future ones, and build laws on that is very clear. So I think that was a great thing for the industry, at least the insight that we got, that okay, it's forward looking, it's future looking. So those were a few things that we really took in a positive manner. And the last piece about the clear clauses in recognizing something like drone ports and UTM systems clearly states that it's not really far away, or it's not something that we are looking or imagining that maybe one day in India we'll have drone ports and maybe we'll be able to do delivery. But there is a clear mandate that okay, it's not just an enabling clause, but also there is an entire detailed schedule which talks about okay, you will have drone ports, there will be licensing, you will have an area that will be demarcated. Even when you talk about UTM solutions, so when the number of drones increases in the airspace, so currently we have about 700 to 1000 manned aircrafts flying in the air. 12 months when the Digital Sky platform is live, probably we'll have about 10,000 or 20,000 drones flying, or even more. This will require new forms of traffic management solutions, something like the UTM platforms. And the mention of the UTM platform in the policy in great detail is something that we thought that it's really forthcoming, and it's really out there that the ministry is intended to sort of manage this traffic and scale it, rather than just having a law which will take care of a few applications. And so the intent to scale this in a big way is clear. And I think that was the key insight that the industry got when you read the rule, in its entirety. So that's the key highlight that I would want to reserve my points with.
Thank you. Thank you so much, for a download, Smith, on the draft rules. And I think as we proceed in this discussion, we would love to, get your insights more from an industry perspective, since you've also been interacting closely. But I'll just keep that on hold for a minute and come back to, every draft of a law which comes in. There are definitely areas which are at times ambiguous, or there are areas which can improve. I'm actually going to touch upon three, four key nuances which are there, from these draft rules perspective. I think the first one is from an applicability perspective. What the draft rule says is that, of course, they extend to India, which means that if there's any drone flying in India or intends to fly in India, these draft rules will apply. But it also goes into impose extraterritoriality. So what it says is that if there is an Indian registered drone anywhere in the world, these draft rules will have jurisdiction over it. I think that is one area which actually hasn't come out very clear. Yes, these sort of extraterritorial jurisdictions are there in other statutes, for example, the Information Technology Act. But that is more linked from an offense perspective, but not from a compliance perspective. So, little bit of clarification or clarity from the regulators would be helpful, because if you have an Indian registered drone and if it is somewhere overseas, you cannot be bound by the compliances and the procedures under these draft rules and Digital Sky platform. It will be more related to the do's and don'ts in the jurisdiction which you want to operate. But yes, from an offense perspective, if the owner is in India and if you need to enforce certain things, then definitely you could do it. So from an extraterritoriality, from a offense perspective, it should have been made clearer as opposed to a general statement. So this was one, key important point specifically, to what this law applies or what these rules apply. I think the second one, which I want to very briefly touch upon, and I'm sure we'll discuss it a little more as we go forward, is introduction of a new category. The introduction of a new category is something called as a model drone, or they've called it a model RPAS, which is a model remotely piloted aircraft unmanned system. They have completely exempted model RPAS from most of the compliance requirements under the draft rule. But the model RPAS de facto come under with two underlying principles. One, they need to be flown within visual line of sight, and second, they need to be for recreational and education purposes. Now, from a normal read of the print and normal intent, if you go back to the old law, this was something which a nano drone could do broadly under the old law, which could be used for recreational purposes and education purposes, which was completely exempt even in that time. But when it came to a nano drone under the old law, there was a certain weight classification which was applicable to it. In the current law, when it comes to the model RPAS, they have actually not gone and given any weight classification to it, nor have they given any restrictions from an operation and ownership perspective. So the entire interplay would be that, the model RPAS could fit in under which category. And completely related to this point is that they have gone and regulated nano drones. I think this is something which we'll discuss further, that a drone which is less than 250 grams, which is could also be a toy drone, to what extent does it need to go and comply with these do's and don'ts under the law? So the takeaway on this point is that yes, the regulations introduce a new category called model drones, uh, very limited purposes, but exempt from most of the compliances. Having said that, under the old law, nano drones which were exempt from compliances have now been regulated. So this is again a key differentiator between the old law. I think third one pain point which keeps continuing is the draft rules tend to build in an ecosystem where they ensure that there is a security check, there is a usage check, there is a ownership check, whereby the entire system is regulated so as to avoid any untoward incidents. Having said that, the question which has been raised by many international players is why can't a foreign company which has a wholly owned subsidiary in India own, operate, or fly a drone? Because even under these draft rules, the restrictions continue, which clearly lay down that uh, ownership of a drone, trading of a drone, manufacturing of a drone at all times needs to be done by an Indian registered company, which is fine. A subsidiary is an Indian registered company of a foreign company. However, that Indian company at all times needs to be owned and controlled by Indian nationals. So this continues, and there were a lot of representations which have been made earlier with the ministry, but even in these draft rules, there have been no relaxation. Probably they could have reconsidered the categorization of relaxation, not for ownership but for operations. But this question remains unanswered. Very quickly, just one more point I'll touch base upon, and then we can discuss it further. Is in the ecosystem, as Smith mentioned, that there are various levels of authorization. So one could be an authorized importer, one could be an authorized owner, one could be an authorized trader. Now the question is that can one person wear multiple hats? Which means that if I'm an owner, can I be the operator? Because somewhere in the draft rules have actually confused it, whereby they have said that if there is a sale from an authorized importer or authorized manufacturer, it can be only to an authorized trader and authorized owner, which means that today can an operator not own a drone? Means the intent, I'm sure, has not been restrictive, but clarity to this extent would have been great. And last but not the least, a lot of interesting concepts have been introduced, drone ports, UTMs, autonomous references of BVLS, which we will talk about. And on this point, probably it would be really interesting if Harshil can step in and give a general overview in terms of what are the new opportunities which are going to be created by these draft rules once enforced. Over to you, Harshil.
Thanks, Huzefa. Yeah, while there are several new concepts and opportunities that have been introduced in the draft rules, which we expect to bring about various positive impacts on the UAS Indian ecosystem. But primarily, four things I would like to cover and according to me stand out. First is the enabling provisions for autonomous and VDLOS operations, followed by introduction of novel concepts such as drone ports and drone corridors in permitted areas, and simultaneously provide creation of a licensing regime attached to it. Further is the establishment of a UTM system or an unmanned aircraft traffic management system like Smith had covered earlier, and I will go in detail to explain how it will impact. Additionally, how a licensing regime has also been introduced for service providers who seek to provide these novel UTM system-based services. Also, another addition in the new draft rules is the recognition of maintenance centers and their impact on the future of the drone ecosystem. So, firstly, on the enabling of autonomous and VDLOS operations, unlike the previous car 1.0, where autonomous operations of UAS were completely restricted, the draft UAS rule proposed to enable these operations but subject to specific conditions as the DGCA may specify. Now, further, the UAS operations previously were restricted to direct visual line of sight of the remote pilot of the observer who is part of who works under the drone operator. The draft UAS rules do not directly or expressly impose any such operational airspace restrictions on UAS operations. Although it needs to be kept in mind that, as Smith already covered, that these are draft UAS rules and specifically derive authority under Aircraft Act. There are various enabling provisions which allow future cars or future regulations to be issued by DGCA to probably cover and specify future conditions to regulate these enabling features. But we believe that these developments will have a significant impact and a boost to UAS based commercial service operations. And the flexibility that this draft rules have in fact provided is in fact a welcoming step. Moving on is the novel concept of drone ports. Now, the draft US rules have introduced this concept of drone ports, which has been given a versatile and a very wide definition. So, drone ports mean any area, both on land or water, and can include buildings, installations, and equipments in any permitted area. Now, because of them being buildings, installations, or equipment, even if it is part of the UAS and is required for the purposes of arrival of the drone, departure of the drone, launching or surface movement of the drone, the component of the maintenance of a drone port will be hit and will be triggered, and specifically a drone port license will be required. Now, interestingly, while only a registered Indian company can get a license for a drone port, we note that the eligibility restrictions do not specifically bar or restrict foreign owned and controlled entities to get the drone port licenses. In fact, considering the capabilities of international players and the potential of future technology collaborations, uh, MOCA in this draft has specifically mentioned that they will in the future specify guidelines if any equity restriction has to be introduced. So we feel that this is a very forward-looking step and will incentivize foreign players to invest in building the requisite infrastructure that we require in the UAS market in India. Another monumental development is the establishment of a UTM system in the Indian airspace. Now, as Smith already mentioned, and just to explain it further, today aircrafts are guided by an air traffic controller system, which allows point-to-point communication to be enabled between the aircraft and the communication system on the ground. Now, currently, there are limited objects in the airspace. because largely the low-level airspace is not utilized, and therefore only manned aircrafts utilize these air traffic management systems. However, as remotely and autonomous UAV operations will continue to multiply, we expect increased activity to take place, and therefore there will be a requirement of a more scalable model which digitally enables management of traffic. And therefore this introduction of a unmanned traffic management system uh, is a welcoming step. Now the draft rules enable the central government to establish this unmanned traffic management system, and but does not restrict foreign players to provide these UTM services within India. Uh, this can also be seen considering in the recently shortlisted players who have been permitted by the DGCA to undertake experimental BBLOS operations. Two of the UTM service providers are in fact foreign entities. Therefore, we believe that the kind of novel and international best practices that these foreign players can introduce for the development of the drone ecosystem will add significant value. Further, there is also a specific regulatory regime for licensing of the training institutes, which will enable the training of UTM personnel who will need to be registered with the DGCA. Now, although right now we are at a very nascent stage and not much clarification is provided as to how and when these UTM training schools will come up, we feel that this is bound to create a large number of employment opportunities in India in the near future. Last but not least is the introduction of a the recognition of maintenance services within the draft UAS rules. Specifically, the draft rules prohibit any operations to undertake without proper maintenance, as per the as per the draft rules. Now, therefore, every UAS manufacturer or UAS importer was authorized to authorized as an authorized person is required to submit a maintenance manual to DGCA. Now, this is important to note that this maintenance manual is required to be part of the mandatory sale documents which will be provided to a UAS owner, operator, or trader for the purposes of exchanging or trading in this drone. Further, these maintenance manuals also permit the establishment of authorized maintenance centers within India. We note that these authorized maintenance centers are not required to be owned and controlled by authorized persons, and therefore do not fall under the authorization regime. However, it is unclear whether foreign entities will be allowed to operate such authorized maintenance centers in India. Uh,
Yep.
that's it from my side. Thank you, sir. Over to you.
Yeah, thank you. Thank you so much, Harshil, for actually highlighting these new variants which are there in the draft policy, which were not there before. I think next probably is one of the more interesting questions and insights that what does the Indian industry feel about it, or what does the global industry feel about these draft rules? And it would be great, Smith, if you could throw some light on that. Specifically, I'm very excited, and I'm sure our audience are equally interested in knowing, drone components and drone parts being treated on par with drones. But in general, the industry feedback, what you have would be great.
Thanks, Huzefa. So I think it's a really hot topic, the regulation of components in the drone industry, I believe. So uh, uh, I think while there was a effort to regularize and sort of control the import of components, but I don't think that is something that will go ahead because of the simple fact that I can import the same battery or the same motor and just call it motor or a battery for a robot, and there are no special regulations or there are no special And I believe that any such dual use component should not be restricted in any manner, because the enforcement of it is impossible in nature. You can't be tracking all the motors and batteries of India to know whether they were, if they were intended for putting it in a robot, are they being put in a robot or not. Just the volume of things don't let you allow that. I think from a components and parts perspective, that is something that uh, I'm not really sure why it was in the draft in the first place, but I don't see that going ahead in the final rules being as it is, because it's a common consensus of the industry, not just the drone industry, every single industry. You can't be regulating every spare part, every screw, everything of the drone industry. Like this literally means that if I'm importing a screw which needs to be fitted in a drone, even that needs to have some kind of sort of import license and import restrictions and all that. So that's something that I don't believe should happen, and I don't think it will happen in the final rules. Uh, some other feedback is that there was a entire classification of nano drones. So before that, there was a classification of model RPAS. So I would like to probably add a few points there. I believe the effort to qualify model RPAS across different weight categories is to equate it to the aero modeling activities that have been happening in India since about 100 years. So an aero modeling activity generally involves drones made out of balsa wood or thermocol, and they have multiple motors, engines, propellers. They keep crashing, keep breaking, parts are being changed, and they are usually flying only for educational or recreational purpose. So I believe that's the category of people that the ministry wanted to capture under model RPAS. So these people generally fly in faraway areas. They don't come in the way of manned aircraft, and it's just usually in a field for a hobby. So the current definition of model RPAS probably recognizes all such drones, and I think if it remains like that, it's a welcoming move, and all these people who were flying RC aircraft since about 80 years or 90 years in India could get covered in that category and may not have to comply with additional requirements of NPNT and all those things. I think that's about the model RPAS, which we thought as an insight, and we wanted it to remain as it is. And change about the model RPAS not having payload. So that's something that we said, maybe recreational drones can have a GoPro or some kind of action cam, which people may use in some competitions or in some recreational activities. So if that could be included, then that will be great. The next major part comes on to the nano drone. So I think there is a performance-based restriction kept on the nano drone. Uh, the sheer number of nano drones that qualify based on the definition, which is the toy drones and all the different drones that are currently available in the market. Uh, well, I'm not sure whether all these drones will be able to comply with the equipment requirements given in the later part of the drone, as well as will be able to sort of comply with the speed requirements. For the simple fact that uh, if there is a drone, then if you need to measure a speed, essentially it needs to have a GPS device. Drones don't really have a GPS device. You just fly them like a radio controlled car. And it's sort of analogous to then say that you want to limit the speed of the car in a case when the car does not have a speedometer. So if you don't have a GPS to measure your own speed, you can't really sort of restrict your own speed. And with about 3 crore toys already out there in the market since years, uh, getting all of them to comply with these new regulations or phasing them out, I wouldn't think would be a good idea. So, hence, if we do want to go towards risk-based or performance-based regulations, I think in the Indian landscape, the industry believes that we need to first enable drone flights. We need to learn, have some experience, and based on that experience, we need to sort of build some risk-based and evidence-based performance regulations. So these were a few things that we had in the introductory part of the policy. Uh, Obviously, then the entire concept of import license and manufacturer license and all of that, we've had some submissions on that it should be as seamless as possible. And one key area, so there is there is a mention about an import license. So the current process, so two things. One point about the manufacturing process, the other one about the import license. So about the import license, there is a current process which in the draft rules state that you need to comply your drone as per the equipment and NPNT requirements, based on which you will get an import clearance and based on which you will get an import license. But when you look at the form of the import clearance and the license, it has fields of serial numbers and quantity, which essentially means that if I am a foreign OEM and I comply with the Indian regulations, or if I'm an Indian guy who is making up my drones in some foreign country, for every batch of import, I need to have an import clearance. So that we believe that should not be the case. If you do comply with the regulations, you should be given a time-bound import license, and probably should be free to import whatever quantity of drones, compliant drones in that particular time frame. So that was one thing. One of the other things was that there is an entire process of certificate of manufacture, which is equivalent to the certificate of compliance in the new law. And there is a small caveat in that. So it says that uh, for you to achieve that certificate of manufacturer, first you need to apply to the DGCA and give a preference of 3 labs where you would want your drone to get certified. And then the DGCA allocates you a lab or a certifying body. And you again go to that certifying body, then get the tests done and get all the certificates, uh, 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 prove them the compliance. And after that, you come back to the DGCA again for obtaining the certificate of manufacturing license. So we believe that these kind of hops between third parties and DGCA should be reduced. Just like any other body, if for example I have a product which I want to certify under a scheme, I should directly be able to go to a lab, give my drone, probably conduct that testing activity 100 times if I require. And in the 100th time, when I have all the clearances and all the tests passed, I can just take all those reports and go to the DGCA and tell them, here is all the reports that you require. Please enlist me on the Digital Sky platform. So when you look at the industry, I think we've really gone into the depth of every clause, and the challenges are on minor issues in the clause rather than something completely gone haywire. So that's my take or the industry's take on the US rules. Huzefa?
No, this was great, Smith. I think thank you. I think the amount of questions which have popped on onto the chat box, I think that actually also shows the real-time interest. And actually, some of our friends are also there from the industry who posted. But we'll come to the Q&A, guys. Just give us. We just have 2, 3 more key points to discuss. And I think most importantly, Smith, what you mentioned is that the infrastructure seems to be there from a regulatory perspective. I think now the next step is implementation, and probably we can discuss that in the closing comments. But Prashant, very quickly over to you. Do you think that there are any missed opportunities in this draft rule, like something which could have been there, or there is some uncertainty? Quick comments would be great.
Sure, Huzefa. So I think before I get into the misses of this of this rule, let me just quickly go into the background of the existing framework that we have, which is by way of a civil aviation requirement. Whereas what has and that civil aviation requirement was issued pursuant to the existing aircraft rules. Now, the idea of replacing the application of aircraft rules on the use of unmanned aircrafts with that of new rules came along with certain other requirements, which basically is a rule that has been prescribed by Ministry of Civil Aviation, but its implementation will be done by DGCA. Now, for DGCA to be able to implement these rules would require certain additional set of guidelines that they may have to prescribe. Now, when these rules have been prescribed, but those additional finer details in forms of in terms of guidelines have not been prescribed, those are going to pose another challenge. And therefore, I feel that one of the misses is that those minor details in terms of implementation of these not being prescribed along with the rules are going to pose challenge in implementing these rules. That's one. Second, while there are certain enabling provisions that we see has been introduced in these rules, there are certain ambiguities and questions arising in the way they have been structured. And most of those we anyway discussed as part of this session. And just to recap, those would be the allowance of model RPAs not being subject to the weight category and being used for experimental purposes, would that something that would get affected because of these rules or not is one question. Second is with respect to one person being able to take multiple authorization, is that something that's possible or not possible? That's again a question that remains unanswered. Then the other question that needs to be looked upon is the beyond visual line operations of drones and the autonomous operation of drones. These are again something that has been allowed, and there are enabling provisions that these operations can be done. But how will these be implemented, or if it will be affected, is again something that the rules are silent on. So civil aviation guideline requirement may be prescribed in future that may shed some light as to how these operations would be done. But at least at this point in time, we feel that it's missing. Then again, another important point is putting a restriction on foreign players to be able to do most of these operations in India is again an important factor, given the kind of precedents we have seen internationally and the kind of success a lot of players have shown internationally. Now, not being able to adapt those forms of technology in India is one of the possible consequences of not allowing foreign players to participate in these activities. So that's again something that I feel is what is missing and could have been considered as part of these rules. And so essentially, these are some of the challenges that I feel. While it is a forward-looking rules that have been prescribed, there are certain lacunas which will hamper the implementation of these rules. So that's where my broad focus is in terms of what is missing in these rules. Jose.
No, excellent, Prashant, for concluding comments specifically in terms of what could have been there, and of course, considering how the regulatory framework is, which Smith and I had briefly mentioned before, that within this, they can actually keep getting better and better, and we hope to do so. On that note, Smith, any concluding comments specifically from a way forward, drone ecosystem perspective?
Definitely, a lot of concluding comments. I believe I would want to categorize them in two parts: uh, compliance to regulation and making drones. So the making drones part actually is not really anything to do with the regulations, but it's more of the opportunity to become a manufacturing economy in India. So largely, we have not been successful in the hardware aspect or the manufacturing of hardware aspect. In large scale when we look at different other industries, and we've been dependent on different Southeast Asian countries or different other countries when it comes to mass manufacturing of electronics and ancillary components. With the drone industry and especially the recent tension, I believe that there is a good opportunity for the drone companies to come together and syndicate their requirement of different components and sort of take cognizance and take that opportunity and start building things in-house. Rather than being an assembler, we should be a manufacturing economy. And there is definitely a lot of focus on that very recently, whether it's from the Ministry of Civil Aviation or whether it's from the industry. So that's one piece which I believe that people should focus on, so that there is no dependency on international players. The second one, from a regulatory perspective, I believe people need to just start asking one question. Whatever we are doing in terms of policy, digital sky, feedback, is it going to enable more drone flights in India? So I think I'm just going to leave everyone, uh, and this comment is for the regulators as well as the industry. I think moving forward, we have to answer one question with all our actions, whether you're creating a new product or whether you're giving feedback on the rules or whether it's the regulator creating new rules. I think we need to clearly base all of that on one particular question: is this activity going to enable more drone flights in India? The objective should be to regulate voluminous number of drone flights and not regulate a particular drone flight, because there is a huge difference between regulating about 700 to 1000 aircrafts between the traditional manned aviation, because scale is never exponential, versus the drone industry where the cost of the equipment is low, anyone can buy them, and if we don't take into account the exponential growth of this industry, probably the regulations will fall flat. So I think that is something that should be the way people should think. Regulators, all of them together, and that's something that should be the way forward. It is the thinking. Huzefa?
No, I think you've actually really summed it up, well, Smith. I think the key and just the main line to all of this, the success story to all of this will be one, the framework is there. How quick can it get implemented, right? Because we all are hoping that the one-stop shop, which is Digital Sky, will actually be functional in a way it was actually understood to be, 6, 8 months back when we got into this process in terms of discussing a one-stop shop digital platform. So implementation of the Digital Sky platform will actually pave the way for the success of the drone industry. And I think the immediate balance which needs to be tested is to what extent will our enforcement arms and agencies be able to regulate in terms of if there are any rogue drones, or if there are any cases. As a team and as part of the overall drone industry, as a firm, we ourselves have actually held workshops with the police and certain state bodies in terms of educating them. But I think that is a key, the enforcement, and second is the implementation. But yes, let's always end on an optimistic note, hoping that once these new rules actually become law, subject to all the consultative feedback which is going to be taken, and hopefully the desired changes will be made, we will be up and rolling soon. On that note, let us actually look through some of the questions. Most of them have been answered, while we have been discussing that. But there are 2, 3 common questions. Probably I can take that, which is in terms of granting exemptions to the government for operating BVLS, which is beyond visual line of sights. And I think there's a second related question: are there any exemptions in general vis-a-vis the government? So specifically from a COVID perspective, there was a notification which came out in March 2020 for a few months, whereby there were certain relaxations which were going to be granted to government agencies to deploy drones. There was a separate portal on which you could apply. More recently, IOC is a success story. The Indian Oil Corporation, which is actually deploying drone faces special exemption. But all of this is visual line of sight. They do not extend to beyond visual line of sight. The BVOLS POCs are still on. I don't think they have been implemented, from an exception perspective. Probably Smith, you can answer this one. On the test sites under the old law, yes, there are certain test sites, which have been designated for, drone operations. Are there test sites for larger drones whereby, people with 2, 3 people inside can actually move?
So, carriage of payload, especially manned payload, is not permitted under the current rules, the CAR 1.0. And there are none test sites in India which are capable of testing something like the Boeing logistics drone that was recently announced, or something that large in nature. So
Or
that,
like a terraphobia or something like that.
that
Yeah.
will need to be tested in traditional airstrips or in unused airstrips. But most of the testing sites do not take into account testing of such large drones currently.
In fact, something with respect to the large drones that need to be kept in mind is that while these US regulations have been specifically introduced to be applicable on unmanned aircraft, there's been a carve out that has been inserted in here that all those drones which are in the large category and are above 300 kgs, they would still be regulated as per the aircraft rules, and not all provisions of the US rules would apply on them. So as far as the test site conditions are concerned, those may be still similar to that of which is applicable on aircrafts.
So, Huzefa, adding a few
Yeah.
points in the earlier question about the exemptions. So, exemptions are being granted whether for public sector units or government organizations for multiple use cases. So, even Maharashtra Transco has recently got an exemption to inspect their power lines. Then we had the anti-locust operations that took into account about 25 drones were flying in 5 cities to spray pesticides on the entire locust problem that was happening, which was a collaborative effort between the Ministry of Agriculture and the Ministry of Civil Aviation. So currently exemptions are being granted on a fast track basis for all government and private sector units, and they are all non-NPNT exemptions. So you can have a non-NPNT drone, and you can apply for all your regular operations, and exemptions are being granted.
Absolutely. And I think just two quick comments on the other questions. I think one was on insurance and the second one was civil criminal liabilities. Yes, under the new rules and under the old law, insurance, there are references to insurance requirements. In fact, specifically in the new law, you cannot operate a UA, which is or a drone, unless you have a valid third-party insurance, which covers damage to property or damage to person. The amounts have not been mentioned, but the intent is there. I'm sure the insurance industry also will have opportunities in terms of offering drone insurance products. Secondly, from a liability and prosecution perspective, under the old law, which is the existing law, there were references to the Aircraft Act and the Indian Penal Code in terms of offenses. Under the current proposed draft rules, in fact, there's a detailed section which talks about, if you breach this particular rule, what would the penalty be? The penalties range up to a couple of lakhs of rupees, and imprisonment can stretch up to a period of 2 years. It's broken into 0 to 6 months for certain kind of offenses, and then the other bucket is more severe. So yes, there has been a thinking from an overall perspective. But on some of these comments, just a couple of minutes, if Prashant, Harshil, or Smith, you want to respond to any of the questions, last 2 minutes, guys, and then we can wrap it up.
Huzefa, I think the question that's there on the liability, I think there is an example that's been cited there, which is if a drone crashes with another drone and an accident is caused due to any technical glitch. So interestingly, the new rules have sort of provided a defense also within the rules that says that if these accidents are caused due to any technical issue and it's something that could not have been controlled or apprehended, then that could be used as a defense for any sort of criminal liability arising out of it. So that's one point I wanted to add with respect to this question.
Absolutely. And I think for the questions, we've actually answered most of those. For the questions which we have not been able to answer, we will separately write back to you guys. So don't worry, it will not go unaddressed. Just on a closing note perspective, I think Nishith Bhai is still on. Nishith Bhai, any overarching closing comments that would be great.
No, I think you all covered excellently most of the points, and future is there. Is for us to shape it further and give a good, So I think together with Drones Association, our team, and the participants, I think let us come together, and because this regime is in the early stages of evolution, and therefore there is an opportunity to shape it rather than something having become hard and fast and then to change is a problem. So I think we would love to have inputs from all the participants and also cooperate, and let's see that we can make more constructive use of drones in the coming times. Thank you.